Everybody is on mute. All right. We have everybody in and they are on mute. If you would like to begin, Chairwoman Tabackin.
Sure. Good afternoon, everyone. Welcome to the August Government Record Council meeting. Please rise for the pledge. I pledge allegiance to the flag of the United States of America
United States of America.
and to the
Republic
for
which
one
stands
nation,
one
under
nation,
God,
under God, indivisible, for all, liberty, and justice for all.
This meeting was called pursuant to the provisions of the Open Public Meeting Act. Notices of this meeting, inclusive of call-in information, were faxed to the Newark Star Ledger, Trenton Times, Courier Post of Cherry Hill, the Secretary of State, on August 22nd, 2024. Members of the public attending the meeting via telephone have been placed on mute by the presenter. At the time that the council arrives at its public comment portion of the meeting, members will be taken off mute and given an opportunity to provide public comment. Please note that the council will strictly adhere to the 5-minute time. Additionally, copies of today's meeting can be accessed on the GRC's website at https://state.nj.us/grc/meeting minutes. Proper notice having been given, the secretary is directed to include statements. Roll call, please.
Robin Beck Tabackin.
Present.
Michael Hahn.
Present.
John Alexi.
Present.
Stephen Ricciardi.
Present.
And Mr. Executive Director, Mr. Caruso, could you please?
Chairwoman Tabackin, is your microphone blocked or something? Because you're like really faint.
Can you hear me now?
Yeah, a little better. It like keeps
Very
going
faint.
in and out, but it's very faint.
All right, hold on. Continue with your report, and I'll go see if I can get one.
Okay. All right. Good afternoon, everyone. I hope everyone's doing well today. As always, we start my report with with our current statistics. Since OPRA's inception in July of 2002, the GRC has received 7,155 denial of access complaints, which averages about 322 annual complaints per a little more than 22 track program years. So far in the current program year, just for everyone's notice, program year is denoted by fiscal year, and we are currently in fiscal year 2025. The GRC has received 41 denial of access complaints. And again, just so everyone knows, fiscal year is July 1st through June 30th. So we're early into the fiscal year. We have 41 denial of access complaints received so far. So of our 7,155 complaints, 563 remain open and active. A breakdown of where they are at in the process is 9 complaints are on appeal, 32 complaints are currently in mediation, 4 complaints are proposed for the Office of Administrative Law, 25 complaints await adjudication by the Office of Administrative Law, 38 complaints are tentatively scheduled for an upcoming meeting, which includes today's meeting. 455 complaints are considered work in progress, meaning that there have been submissions or they're in the submissions process, but they have not been scheduled for a meeting yet. As for our inquiries, since program year of 2004, the GRC has received and responded to 39,506 total inquiries, which averages about 1,863 annual inquiries per a little more than 21 track program years. As always, we note that the GRC did not track in our first program year. So far in the current program year, again, fiscal year 2025, the GRC has received 252 inquiries, which is about 6.3 inquiries per workday. As for our outreaches, the GRC has 3 outreaches coming up between now and our next monthly meeting. The first will be held tomorrow, August the 28th, virtually, and is hosted by the League of Municipalities. The second presentation will be on September 5th, 2024. That will also be virtual, and it'll be for all of our state level custodians and support staff in the department there. Finally, the third presentation will be on September 18th. I'm taking the long 2-hour drive up to Newton, New Jersey, to join the Sussex County Municipal Clerks Association. I believe it's their bi-monthly meeting. So we'll be up there doing that. Finally, as for our pending Oprah legislation, safe to say we are on the verge of it no longer being pending. So I have the following statement for us on this point. So the unofficial end of the summer is less than a week away. In a bit of a poetic sense, with the turning of the calendar comes the end of an Oprah era and the beginning of another. For the last 22 years, almost 18 of which I've been with the GRC, Oprah has been shaped by requesters, custodians, and of course, litigation. The GRC has been an integral part of this history through the myriad of council decisions, online resources, and training opportunities. On September 3rd, 2024, next Tuesday, a week from today, Oprah is not going away. It's simply evolving into a new phase. With this evolution comes many changes, including new statutory language, new council and staff members, and new processes. The GRC is prepared to meet these challenges head on. As former director Catherine Stargill often demanded, it is now up to the GRC to recommit to quickly re-solidifying our status as Oprah experts. In the coming months, the GRC will address these significant changes to Oprah with updated versions of those resources on the GRC's website that have long been of value to the Oprah community. We will also be conducting our annual seminar this year with an obvious focus on the new version of Oprah. Date still TBD, but hopefully we will get that out soon. However, of immediate import and likely paired with a hearty sigh of relief from public agencies around the state, we're pleased to announce that our adoptable Oprah request form portal will be going live tomorrow, August 28th at 2 p.m. So this is the new version of Oprah will require agencies to adopt our established form, whereas previously it was optional, not mandatory. As of September 3rd, it will be mandatory. So our portal will allow agencies to do that, hopefully very seamlessly. It will go live tomorrow at 2 p.m. and we'll post further details on our homepage as soon as possible. So that's the big announcement at the end of my director's meeting. My director's report is that the adoptable Oprah request form, which we've gotten so many questions, will be live tomorrow at 2 p.m. and agencies can, at their leisure, begin adopting our Oprah request form. And that is all I have.
All right, thank you very much. Can you hear me now?
Yes.
Much better.
Much better.
All right, we do not have a closed session, so we move into approval of the minutes from the July meeting. Is there any discussion on the open session meeting minutes from July 30th, 2024? Hearing none, could I have a motion to approve?
I'll move. Second.
Robin Bertolaki,
Yes.
Michael Hahn,
Yes.
John Alexi,
Yes.
Stephen Ricciardi.
I'm going to abstain since I was not present at the last meeting.
Okay, thank you. All right, we need to add the closed session meeting minutes to the agenda for July 30th, 2024. Is there any discussion on that? Okay, could I have a motion to approve, please?
I'll move. Second.
Robin Bertolaki,
Yes.
Michael Hahn,
Yes.
John Alexi.
Yes.
Thank you. We now move into new business. Cases scheduled for consent agenda, administrative complaint disposition adjudication. An administrative complaint disposition means a decision by the council as to whether to accept or reject the executive's the executive director's recommendation of dismissal based on jurisdictional, procedural, or other defects of the complaint. The executive director's recommended reason for the administrative disposition is under each complaint below. We have on the consent agenda one complaint with a recusal, so that would be Mr. Retardi. You have to mute, cannot vote. Thank you. Rotimi Owa Esquire, on behalf of African American Data and Research Institute v. Saraville Borough Police Department, Middlesex, 2022-110. All records responsive, provided in a timely manner. Could I have a motion to approve that, please?
I'll move. Second.
Robin Back-to-Backing,
Yes.
Michael Hahn,
Yes.
John Alexi.
Yes.
All right, Mr. Retardi, you can unmute. The remainder administrative disposition adjudications have no recusals, and there are 13 of them. I will read them and we will vote at the end. Rotimi Owo Esquire, on behalf of African American Data and Research Institute v. Bernards Police Department, Somerset, 2022-79. All records responsive, provided in a timely manner. Rotimi Owo Esquire, on behalf of African American Data and Research Institute v. Branchburg Police Department, Somerset, 2022-82. All records responsive in a provided in a timely manner. Rotimi Owo Esquire, on behalf of African American Data Research Institute v. Westwood Police Department, Bergen, 2022-96. All records responsive, provided in a timely manner. Rotimi Owo Esquire, on behalf of African American Data and Research Institute v. Mount Laurel Township Police Department, Morris, 2024-104. All records responsive, provided in a timely manner. Rotimi Owo Esquire, on behalf of African American Data and Research Institute v. Voorhees Township Police Department, Camden, 2022-107. All records responsive, provided in a timely manner. Rotimi Owo Esquire, on behalf of African American Data and Research Institute v. Cranberry Police Department, Middlesex, 2022-121. All records responsive, provided in a timely manner. Rotimi Owo Esquire, on behalf of African American Data and Research Institute v. Delanco Township Police Department, Burlington, 2022-122. All records responsive, provided in a timely manner. Rotimi Owo Esquire, on behalf of African American Data and Research Institute v. Hopewell Township Police Department, Mercer, 2022-123. All records responsive, provided in a timely manner. Rotimi Owo Esquire, on behalf of African American Data and Research Institute v. Hanover Township Police Department, Morris, 2022-127. All records responsive, provided in a timely manner. Rotimi Owo Esquire, on behalf of African American Data and Research Institute v. Lower Township Police Department, Cape May, 2022-153. All records responsive, provided in a timely manner. Rotimi Owo Esquire, on behalf of African American Data and Research Institute v. Monroe Township Police Department, Gloucester, 2022-154. All records provided in a timely manner. Vernon J. Meenan Jr. v. Township of Edgewater Park, Burlington, 2024-32. No records responsive to the request exist. Andrea Ryan Faccarello v. Town of Newton, Sussex, 2024-90. All records provided in a timely manner. Could I have a motion to accept those, please?
Move. Second.
Robin Back-to-Backing,
Yes.
Michael Hahn,
Yes.
John Alexi,
Yes.
Stephen Retardi.
Yes.
Okay. Administrative disposition, uncontented, voluntary withdrawals by complainant. There's no adjudication of the council required. However, I will read them. There are 9. Scott Madlinger v. Hohokus Board of Education, Bergen, 2023-224. Complaint settled in mediation. Maximilian Hayden v. Rutgers University, 2024-13. Complaint settled in mediation. Kevin M. Barron v. Hudson County Prosecutor's Office, 2024-43. Complaint settled in mediation. Tyler LaFrance v. NJ Transit 2024-48, complaint settled in mediation. John C. McMahon Jr. v. Voorhees Township Police Department, Camden 2024-72, complaint settled in mediation. John C. McMahon Jr. v. Voorhees Township Police Department, Camden 2024-78, complaint settled in mediation. Joy Bembry v. City of Newark, Essex 2024-163, complaint voluntarily withdrawn. William J. Capuccio v. Township of Mullica, Atlantic 2024-164, complaint voluntarily withdrawn. Joseph Terulli v. Township of Cranford, Union 2024-189, complaint voluntarily withdrawn. All right, now we move into new business. Cases scheduled for consent agenda administrative order. An administrative order means an order issued by the council requiring the records custodian or the complainant to perform a specific action in furtherance of the adjudication of a pending denial of access complaint or taking other actions deemed appropriate to adjudicate a complaint in an expedited manner. The executive director's recommended reason for the administrative order is under each complaint below. However, we do not have any administrative orders with or without recusals. So we move into new business cases scheduled for individual complaint adjudication. We have two cases with Mr. Ritardi recused. Please mute. Thank you. Louis S. Mando v. County of Essex 2022-128.
The custodian lawfully denied access to user agreements between inmates and Global Tel Link, or GTL, because they are exempt from disclosure under NJAC 10A:30-6.10A12, NJSA 47:1A-9A, and Lugo v. New Jersey Department of Corrections, GRC complaint number 2017-8, March of 2018. The custodian unlawfully denied access to the contracts between GTL and Essex County Correctional Facility because same are generalized and not associated with individual inmates, NJSA 47:1A-6. The custodian shall disclose the responsive contracts or certify if none exist. The portion of the request seeking types of GTL media is invalid because it sought information. MAG Entertainment LLC, the Division of Alcoholic Beverage Control, 375 NJ Super, 534 Aptiv 2005, Lamantia v. Jamesburg Public Library, Middlesex, GRC complaint number 2008-140, February of 2009. Thus, the custodian lawfully denied access to same, NJSA 47:1A-6.
Thank you. Is there any discussion? Hearing none, motion please.
I'll move. Second.
Robert Brett-Tabakin,
Yes.
Michael Hahn,
Yes.
John Alexi,
Yes.
Andrew H. Graulich, Esquire, on v. City of Newark, Essex 2024-128.
The custodian's failure to submit a statement of information resulted in a violation of NJAC 5:105-2.4A. The custodian's failure to respond within the extended time frame resulted in a deemed denial of access, NJSA 47:1A-5G and 5I, as well as Cone v. Township of Livingston Library, Essex, GRC complaint number 2007-124, March of 2008. The complainant's request was invalid because it sought generic records. MAG 375, NJ Super 534, Bent v. Stafford Police Department 381, NJ Super 3037, Aptiv 2005, Lagerquist v. Office of the Governor 443, NJ Super 230, 236 and 37, Aptiv 2015. Thus, notwithstanding the deemed denial, the custodian did not unlawfully deny access to the request, 47:1A-6, and the complainant is not a prevailing party.
Thank you. Is there any discussion? Hearing none, could I have a motion, please?
I'll move. Second.
Robert Brett-Tabakin,
Yes.
Michael Hahn,
Yes.
John Alexi,
Yes.
All right, thank you. Now we move into individual complaint adjudications without any recusals. Thank you, Mr. Tardy. Rotimi Owo Esquire on behalf of African American Data and Research Institute v. Haworth Police Department, Bergen, 2022-49.
The custodian lawfully denied access to the portion of the complainant's OPA request seeking agreements because she certified, and the record reflects, that no records exist. Brewster Hopper v. New Jersey Department of Education, GRC complaint number 2005-49, July of 2005. The custodian unlawfully denied access to the portion of the complainant's OPA request seeking personnel information because the disclosed spreadsheet was derived from individual physical records, Valdez v. Union City Board of Education, Hudson, GRC complaint number 2007-156, February of 2008.
2 times.
Custodian shall thus locate and provide such records. The complainant is a prevailing party. The party shall confer on fees and advise the GRC within 20 business days if an agreement is reached. If not, complainant's counsel shall submit a fee application in accordance with NJAC 5:105-2.13.
Thank you. Is there any discussion? Hearing none, motion please.
So move.
Second.
Robin Bexabakin,
Yes.
Michael Hahn,
Yes.
John Alexi,
Uh-oh.
John
Did
Alexis.
we-
He's muted.
Alexi?
You're muted. You hear that again,
John
please?
Alexi, yeah.
Mr. Alexi, could we have a vote?
Yes. Sorry about that.
Thank you.
City Retarded,
Yes.
Rotimi Owo Esquire on behalf of African American Data and Research Institute v. Lyndhurst Police Department, Bergen, 2022-68.
The custodian's failure to submit an SOI resulted in a violation of NJAC 5:105-2.4a. The custodian unlawfully denied access to the portion of the complainant's OPA request seeking disclosable personnel information, Danis v. Garfield Board of Education, Bergen, GRC complaint number 2009-156, EdSec, interim order dated April 28, 2010. The current custodian shall locate and disclose the responsive personnel information or certify if none exists. The custodian may have unlawfully denied access to the portion of the complainant's OPA request seeking agreements, 47:1A-6. The current custodian shall perform a search and either disclose those agreements located or certify if none exist. The prevailing party analysis is deferred.
Thank you. Is there any discussion? Hearing none, motion please.
So move.
Second.
Robin Bexabakin,
Yes.
Michael Hahn,
Yes.
John Alexi,
Yes.
City Retarded,
Yes.
Rotimi Owo Esquire on behalf of African American Data and Research Institute v. Ewing Police Department, Mercer, 2022-81.
The custodian lawfully denied access to the portion of the complainant's OPA request seeking agreements because she certified and the record reflects that no records exist. Brewster Hopper, GRC 2005-49. The custodian unlawfully denied access to the portion of the complainant's OPA request seeking personnel information because the disclosed spreadsheet was derived from individual physical records, Valdez, GRC 2007-156. The custodian shall thus locate and provide such records. The complainant is a prevailing party. The party shall confer on fees and advise the GRC within 20 business days if an agreement is reached. If not, complainant's counsel shall submit a fee application in accordance with NJAC 5:105-2.13.
Thank you. Is there any discussion? Hearing none, motion please.
So move.
Second.
Robin Bexabakin,
Yes.
Michael Hahn,
Yes.
John Alexi,
Yes.
City Retarded,
Yes.
Rotimi Owo Esquire on behalf of African American Data and Research Institute v. Una Borough Police Department, Atlantic, 2022-83.
Got it. Unit. The custodian's response.
We can't hear you.
No.
Do you have me now?
Yeah.
Now I can. Yes, now I can.
So for the record, Teams has been doing this thing where it has decided to change microphones midstream and or lose microphones. So that may occur once or twice. I don't know. Teams was working and then Microsoft decided that they didn't want it to work as well anymore. So if I should cut out again, let me know and I'll get my microphone up again. But I was just commenting that, yes, Buna, you got it. So we'll begin again. The custodian's response was insufficient because she failed to address each OPA request item individually. 47:1A-5G, PATH v. Willingboro Board of Education, Burlington, GRC complaint number 2007-272, May of 2008. The custodian lawfully denied access to the portion of the complainant's OPA request seeking agreements because she certified, and the record reflects that no records exist, Pusaroffer, GRC 2005-49. The custodian unlawfully denied access to the portion of the complainant's OPA request seeking personnel information because the disclosed spreadsheet was derived from individual physical records, Valdez, GRC 2007-156. The custodian shall thus locate and provide such records. The complainant is a prevailing party. The party shall confer on fees and advise the GRC within 20 business days and if an agreement is reached. If not, complainant's counsel shall submit a fee application in accordance with NJAC 5:105-2.13.
Thank you. Is there any discussion? Hearing none, motion, please.
So moved.
Second.
Robin Beck-Tabakin,
Yes.
Michael Hahn,
Yes.
John Alexi,
Yes.
Terry Retardi,
Yes.
Scott Madlinger v. Berkeley Township Ocean 2022-149.
The custodian violated 47:1A-5F by seeking a deposit from the complainant who filed his OPA request anonymously, although the anticipated cost was less than $5.
Is there any discussion? Hearing none, motion, please.
So moved.
Second.
Robin Beck-Tabakin,
Yes.
Michael Hahn,
Yes.
John Alexi,
Yes.
Terry Retardi,
Yes.
Vincent Lepore v. City of Long Branch, Monmouth 2022-157.
The custodian's extensions were warranted and substantiated, thus no deemed denial of access occurred. 47:1A-5G and 5I. Rodriguez v. Keene University, GRC complaint number 2016-87, April of 2018. The custodian did not violate OPRA by charging the actual costs associated with disclosing the responsive records on flash drives. The custodian is not required to disclose the responsive records until the complainant remits payment of the actual current costs to disclose the records. Santos v. NJ State Board of Parole, GRC complaint number 2004-74, August of 2004.
Thank you. Is there any discussion? Hearing none, motion, please.
So moved.
Second.
Robin Beck-Tabakin,
Yes.
Michael Hahn,
Yes.
John Alexi,
Yes.
Terry Retardi,
Yes.
Marcus L. Kirschenbaum v. Wall Township Public Schools, Monmouth 2022-259.
The complainant's February 14th, 2022 request seeking a list is invalid because it sought information. MAG 375 NJ Super 534, Lamantia GRC 2008-140. Further, the complainant's April 11th, 2022 requests are invalid because they sought information that would have required research and or the creation of a record. Thus, the custodian lawfully denied access to these requests. 47:1A-6. Custodian did not unlawfully deny access to the portion of the complainant's OPA requests, complainant's March 22nd, 2022 OPA request seeking personnel information because all was disclosed. Danis 2009-156 ed sec.
Thank you. Is there any discussion? Hearing none, motion, please.
So moved.
Second.
Robin Beck-Tabakin,
Yes.
Michael Hahn,
Yes.
John Alexi,
Yes.
Clara Tati,
Yes.
John Paff v. Wall Township, Monmouth, 2022-662.
The custodian unlawfully denied access to the portion of the complainant's OPRA request seeking payroll records related to Sergeant Cadigan under the basis that it was invalid. Danish GRC 2009-156 ed sec. The custodian unlawfully denied access to the requested leave status 47:18-10 Jackson v. Keene University GRC complaint number 2002-98 February of 2004. However, the GRC declines to order any further disclosure because the custodian acknowledged that Sergeant Cadigan was on paid leave during the identified time frame, and complainant's counsel acknowledged this disclosure. The complainant is a prevailing party. The party shall confer on fees and advise the GRC within 20 business days if an agreement is reached. If not, complainant's counsel shall submit a fee application in accordance with NJAC 5:105-2.13.
Thank you. Is there any discussion? Hearing none, motion, please.
So moved.
Second.
Robin Beck-Tabakian,
Yes.
Michael Hahn,
Yes.
John Alexi,
Yes.
Clara Tati,
Yes.
All right, we move into court decisions of GRC complaints on appeal. There are none. There are complaints adjudicated in New Jersey Superior Court and New Jersey Supreme Court.
Thank you, Madam Chair. As you stated, there's 3 cases for appeal. The first is Latoki versus Port Authority of New York and New Jersey, 2024 NJ Super Unpub Lexus 1930. The plaintiff requested video footage from the defendant on September 1st, 2022. Thereafter, the plaintiff and defendant traded communications until the plaintiff stated that if he did not receive a response by October 21st, 2022, he would consider the request denied. On October 14, 2022, the defendant responded to the plaintiff, stating an extension was needed until November 4th, 2022. On November 16, 2022, the plaintiff gave the defendant another ultimatum of November 22nd, 2022. The defendant responded, stating they would respond by December 15th. On December 15th, the defendant again extended the date of response to January 12th. On December 21st, the plaintiff emailed the defendant stating he would file an action in court if he did not receive the footage by January 12th, 2023. On January 3rd, the plaintiff filed this action against the defendant, and on January 5th, the defendant provided the requested footage. The trial court held that the plaintiff filed his action outside of the 45-day period. The trial court found that the deadlines the plaintiff issued in his communications with the defendant marked the beginning of the period, and regardless of whether the clock started on October 21st or November 4th, the plaintiff's action was untimely, and the trial court therefore dismissed the action. On appeal, the appellate division found that because the defendant provided responsive records on January 5th and January 13th, the issue of the statute of limitations was moot, and all that remained was the issue of attorney's fees. The court found that because the plaintiff stated that he would file an action against the defendant if they did not meet the January 12th, 2023 deadline, he effectively agreed to the deadline set by the defendant. The court held that because the defendant provided the requested video 9 days prior to the January 12th, 2023 deadline, the defendant's response was not motivated by the pending litigation, but in line with the agreed upon deadline. The court therefore held that the plaintiff did not satisfy the catalyst theory and was not a prevailing party under Court Rule 4:42-8A. In the next case, this case has been marked approved for publication. In re adoption of NJAC 5:105-1.6A1, the 2024 NJ Super Lexus 84. The Government Records Council promulgated a new regulation, NJAC 5:105-1.6A1, stating that all submissions to the GRC regarding a complaint would not be subject to OPRA while said complaint was pending adjudication. The plaintiffs challenged the regulation, arguing that the regulation was inconsistent with and in contravention to the purposes of OPRA. The appellate division found that the provision directly contravened OPRA, which requires that government records are to be provided within 7 business days, whereas the regulation would delay the release of the submissions to however long the GRC takes to adjudicate the complaint. The court further held that OPRA did not include submissions to the GRC among its list of exemptions to get access, and the GRC did not point to any statute which authorized this exemption. The court also held that the exemption would undermine the ability of potential interveners to discern whether they are entitled to intervene in an ongoing complaint. Moreover, the court found that the GRC's basis for the regulation is undermined further because the exempted submissions may be obtained via OPRA from a public agency that is a party to the complaint. The court thus held the regulation invalid. Finally, we have Zempel versus Morris County Prosecutor's Office, 2024 NJ Super on Pub Lexus 1998. On January 12, 2022, the plaintiff submitted an OPRA request seeking several records pertaining to his criminal matter. The defendant denied the request, stating primarily that the request essentially sought previously provided discovery and that OPRA was not intended as a substitute for discovery. The trial court held that the requested records were exempt as criminal investigatory records and noted that the plaintiff had access to the requested records throughout his criminal proceedings. On appeal, the appellate division held that because there were no pending post-conviction relief applications, there was no reason to overturn the trial court's determination that the request sought criminal investigatory records, and affirmed.
Thank you very much. All right, there are no complaints adjudicated in U.S. District Court, so it is time for public comment. The public comment period is limited to providing an opportunity for speakers to present suggestions, views, and comments relevant to the council's functions and responsibilities. In the interest of time, speakers will be limited to 5 minutes. Speakers shall not be permitted to make oral or written testimony regarding pending or scheduled adjudications. Mr. Crusoe.
All right, everyone. So for our attendees today, if you are interested in making public comment today, you'll want to press *6 on your telephone. *6 will allow you to unmute, and that will give you the ability to make public comment. Oh, we do have a taker. We'll just need your name, and then you can give your public comment.
Oh, Vincent Lepore, can you hear me?
Yep, we got you, Mr. Lepore.
All right, you made a determination on my matter, 2022-157. Could you please tell me, what is my position right now if the records have been destroyed by the custodian?
So I'm not entirely sure I understand the question. So your question is what happens in a situation where a requester requests a record and then it's subsequently destroyed?
Yes, you've made a decision and the records have been destroyed. What is the position of the GRC now? You made a decision on records, but the records have been destroyed.
So I don't know if it's a question I can answer. I mean, this sort of borders into discussion of the actual physical case as opposed to just a general public comment. So, unfortunately, I can't speak to the facts of it. I think that it might be prudent to contact your complaint manager once you've received the decision if you have questions about it. And then if we can answer, a question about your concerns about the decision, then we certainly will endeavor to do so.
And my complaint manager will be John Stewart, is that correct?
Yep, Mr. Stewart. Yep.
All right, thank you.
All right. Thank you, Mr. Lepore. All right. So do we have any other individual? *6 is how you give public comment. Any other individuals who are interested in making public comment today? We'll give a little bit of time for people to think about it. *6. *6 would be how you would unmute if you were interested in giving public comment. About another 10 seconds. Again, *6 for anyone interested. 5 seconds. *6 going once. Going twice. *6. Any last takers? All right, it looks like our public comment period is concluded. Okay, so we're pretty much on our last agenda item here, but obviously knowing that on September 3rd, we're going to have a host of changes here. I'd like to give our current council members a chance to give some final remarks, as this will likely be, their last meeting under this current iteration of the council. So we'll begin with, if either Mr. Hahn, if you have any few last parting words, we'll start with you, and then we'll kind of move our way up through to Chairwoman Tabackin.
Thank you, Frank. I just want to say it's been, a pleasure serving with everybody and working with everyone here for the past, I guess, little over a year and a half. I enjoyed my time, and I look forward to watching and seeing how the council evolves in its next iteration.
Thank you. Thank you, Mr. Hahn. We appreciate your participation on behalf of the DOE Commissioner, and in a long line of good designees that we've appreciated over the years. So much appreciated. Mr. Alexi, this is kind of an odd situation for you because according to the new statute, you will be back next month, just serving in a different capacity.
Well, I have enjoyed my time, and I look forward to the next iteration of the council if I'm chosen to continue to participate. And I've enjoyed my time with the other council members.
And yeah, we'll see where September takes us. All right, Mr. Ritardi, the second longest tenured council member, we'll give you the floor.
It has been quite a tenure. So as Mr. Caruso, Frank, you previously used the word era. It's absolutely a good word. I guess my appointment goes all the way back to Catherine Stargill when she was executive director. And after Catherine, I believe there had been, and I could be wrong, but there have been 4 executive directors leading up to Frank, who supported each one of his predecessors and candidly helped educate us all. And as to Mr. Caruso and his staff, John and Sam, neither Westlaw nor LexisNexis or any other data bank can keep up with you, and that's not an exaggeration. You all do yeoman's work, which the new council members will soon come to realize and appreciate, as Robin and I have. It's been an honor to work with the DCA and the Department of Education, and particularly John and Michael, over this last year plus. And Rose, you have been where are you on my screen? Rose, you have been a delight, and I will miss you. I'm sure we all will miss you calling out our names on roll call.
Yeah.
And of course, we all benefited from the Attorney General's office's good counsel, mostly under my tenure and Robin's tenure with Deborah Allen, and today Mark. And I'm especially thankful to Robin. Robin, for your outstanding leadership and commitment after all these years. So to sum it up, I've enjoyed working with everyone, and I'm truly grateful for my service and time on the GRC. I wish New Jersey and its newly minted council good luck and good wishes to a new era that remains in good hands with this executive director. And to borrow a word from one of my mentors in this profession, peace.
All right, well, thank you. Yeah, Stephen, I remember just briefly when you came in, we were in this situation where we were rolling cases over because we didn't have a quorum on recused cases. So we had to keep rolling this building line of cases. I think we were up to 20 plus cases by the time you came to your first meeting. We were able to get rid of them all at once. And we were grateful for the help coming in at that time. And, certainly you've been a great value to us. As our council members have been, you've been a great value to us, especially in some of our discussions about attorney's fees and attorney billing invoices in camera. So much appreciated. And
Thank you, Frank.
yeah, very, very much appreciated. All right.
Thank you. Yeah, I I remember I was popular when I came in.
Very popular. You were very popular. All right, Chairwoman Tavakin, you
still
have
popular.
final say.
All right, thank you very much. It's been an honor and a privilege to serve as a public member of the New Jersey Records Council since 2005 and as chairwoman since 2007. Over the past years, the council has relied on a dedicated team committed to transparency, accountability, and the principles of open government. I want to express my sincere gratitude for the hard work and dedication of the Government Records Council staff and executive directors over the years, including Catherine Stargell, Acting ED Karen Gordon, Brandon Mindy, Acting ED Don Sanfilippo, Joe Glover, and our current ED, Frank Caruso, to which we owe a great debt of gratitude. I'm also deeply appreciative of my colleagues on the council, including the representatives from the Department of Community Affairs, all of them that have come back from the past, and John, and also from the Department of Education, Michael, as well as public members, notably my longtime colleague, Steve Riccardi. Thank you, Steve. Since the adoption of the Open Public Records Act in 2002, the council has been tasked with the important responsibility of interpreting the legislature's intentions and shaping the law to ensure that public access to government records is maintained while also respecting privacy, confidentiality, and security where required. I'm proud of the diligent efforts the council has made to strike this balance, and I believe we've played a significant role in advancing the public's right to know and promoting open governance. I'm deeply grateful for the trust that the public has placed in the council over these many years, and it's been a profound experience to contribute to the council's mission. Together, we've upheld the values of transparency and public service, albeit not without its challenges. As I step down as chair, I'm confident that the council will continue its vital work with the same dedication and integrity that has characterized our efforts thus far. I extend my heartfelt thanks to my fellow council members, the GRC staff, and all those who have supported us along the way. I just want to mention Sam, John, and Rose. You've been here, I think, almost as long as me. So thank you very much. And thank you for the opportunity to serve. It's truly been an honor. Oh, and also the Attorney General, yes. In particular, Deborah Allen.
Don't worry, DAG Go Branson. One day I'll be you.
Looking forward to it.
Well, so yeah, this is obviously a bittersweet meeting. I appreciate everyone's remarks. Robin, we've been through it for about the last 18 years, and certainly with Stephen, John, and Mike, you two have come along a little more recently, but still have seen some of the work that's been done. From the GRC's position, we appreciate you all. No one understands that you're not getting any additional pay for this. This was at least up until September 3rd for the new council members who will be equally dedicated, I'm sure. But up to this point, your positions were voluntary based on appointments. You took on many great difficult discussions to further the question of transparency in the state. You've made our lives easier here at the GRC. So we're going to miss you guys. This is sort of a bittersweet deal. I don't know where we're going to be in September. Hopefully, we'll know soon enough who we'll have coming in. But we're going to miss you guys otherwise. It's a strange feeling out there today. The heat comes back and we're all saying goodbye, but hopefully this isn't goodbye, but just, we'll talk soon. Hopefully we can all keep in touch and track the progress of this agency as we step into Oprah 21st century. So thank you all very much. It's been a pleasure. And we can, I guess, now move on for the last time to the final easy vote of this iteration of the GRC.
All right, final adjournment for this tenure. Could I have a motion to adjourn, please?
So moved.
Seconded.
Robin Beck-Tabaki,
Yes.
Michael Ham,
Yes.
John Alexi.
And Robin, you are leaving very big shoes to fill. You've done a great job. Yes.
Thank you very much.
Steve Riccardi.
Yes.
All right. Well, I appreciate
We
it.
are,
It's been fun. It's weird, but it's been fun. And we shall talk sometime here or in the future. Thank you everyone for attending today. And some of us will see you all in September. Bye.
all right. We are
All right.
adjourned.
Have a good one. Thank you.
Take care, everyone.
Thank you,
Madam
guys.
Chair. Thank you.
Thank you very much.
Bye, everyone.
Bye.